HMRC applicants, post-prudential closure notice group and another.
Yes, Mr. Ewart.
Good morning. First thing is double tax treaties, and I hope that we've handed up a file.
Yes.
This contains, for completeness, all the double tax treaties in relation to the countries that were listed, if you remember, in the schedule. We don't have to look at them all, obviously. Just to note, as a matter of interest, Greece, which is the first one, is slightly unusual in that it has the normal credit relief provision generally for credit for tax, juridical double taxation on the same income, but it doesn't have a two-way underlying tax provision. It only gives credit in Greece for UK tax. For some reason, there is no provision for credit for Greek tax in the UK. This was 1953 treaty, and it may be at that time under the system that we had then it wasn't necessary. I really don't know. But in any event, it doesn't matter because you would of course claim unilateral relief for underlying tax in the UK for Greek tax under Section 790.
But does it limit the withholding tax, right?
Yes, there is a dividend article. I was going to show you the French treaty, which is a bit more typical, which is the second tab. So the dividend article is on page 12.
Sorry, I've only got.
Tab 2. Page 12.
Tabbing's gone wrong.
All right, sorry. Tab 2 is that the French treaty you've got?
I found it on page 12, but not
Yes.
on tab 2. Maybe someone could just sort the tabs out.
Yes.
I think my lady has been disadvantaged because mine is fine.
Mine's okay as well.
Okay, sorry. So page 12, the dividend article, and you'll see an A at the top. This is referring to dividends paid by companies which are resident in the UK to France, and there is a limit on the amount of withholding tax credit.
Is this relevant for our purposes?
Well, it's just for completeness, so you can see that there is, if you remember, the reference to the treaty rate of tax, and B deals with the other way around. So the treaty rate there would be 5% or 15%, depending on circumstances. But the more important article, my lord, is Article 24, which is on page 14, which is the equivalent of the unilateral relief provision that you've seen. So the relevant part is A 1 and 2, because that deals with French tax. So little Roman 1 deals with juridical double taxation, that is taxation of the same income on the same person, doubly. And then little 2 is the provision that deals with economic double taxation, so it gives relief for underlying tax.
But not for portfolio holdings.
But not for portfolio holdings, yes. 10% is very typical in treaties. Some treaties, I think the Greek treaty in fact has 25% as the limit, but that's just again a matter of negotiation. Now, can I just say something about double tax treaties, because I think it is important to understand that the Article 24A1 does not just apply to dividends. It applies in all situations where the double tax treaty, particular article relating to the particular source of income, for instance, interest or business profits or whatever, allows both states to tax the income. Some articles provide that only one state can tax it, in which case there's no double tax problem to be dealt with under the credit relief. But some articles say that effectively say both states can tax it. So that would apply to other forms of sources of income. So it's not just dividends we're talking about here. I think it's important to understand that, as I've just come on to, that the arguments being put forward still has importance, even though that we now exempt dividends in the UK from foreign dividends. It would still have importance because it would apply if my learned friend is right, to all claims for double tax relief credit.
It may not be relevant, but one always has to remember also that, I mean, ultimately, we have to look at, or one might have to look at section 788, just because it's not every provision in the DTT which is actually given domestic force.
I was going to do that, my lord, just to show how these treaties are given effect, because on their own, they're simply international treaties which have no effect in UK law. They're given effect by section 788, which is in the bundle.
Well, and the Order in Council made.
788 and the Order in Council under 788, exactly. So there will be an Order in Council in relation to all these treaties in which they are a schedule and they're given effect by the Order in Council. But they can only be given effect, as I think my lord is saying, insofar as they give relief from income tax or corporation tax in respect of income or chargeable gains.
I mean, right, there have been cases where that's been important to decide whether in fact the relief in question is incorporated into domestic law or not.
Exactly. And there was a case called NEC Semiconductors,
That rings a bell.
which I think, I can't remember if you lordship or Mr. Justice Park may have heard it, I can't remember who it was now. But it was very important as to whether ACT was corporation tax on income and chargeable gains, and it was held it wasn't, in fact, for reasons I won't go into now.
We've got enough complications in this case.
Yes,
without
yes,
having
yeah.
unnecessary ones, so I didn't want to start a hair, but
Yeah.
it's just a reminder.
But my point is, if my learned friend is right that there is one claim for double tax relief, I think that's the way he puts it, then that would encompass not just dividends, but all possible credit claims for double tax relief. And that would mean, it would seem, the logical conclusion to that is, by putting in a claim for £2,000 of withholding tax credit, one has made a claim which can encompass all DTR claims. And that would seem to mean, as a practical matter, that in an inquiry, the revenue might be inquiring into the return as it stood, and a number of years later, when they were just about to close the inquiry, the taxpayer might say, oh, sorry, I forgot about £2 million of credit relief I've got in relation to interest or whatever, business profits or whatever it is.
Would they not have to make a supplementary claim within the
Well,
time limit?
well, that's the oddity about all this. I don't understand why they would, because they've made a claim. It's in the inquiry. So once you've made a claim and it's in the inquiry, then it can be adjusted in the inquiry. And that's what they rely on, the fact that they can adjust this claim. So they say, well,
Can I make sure I understand that? Because the case law tells us that a claim needn't be quantified.
it needs to be quantified.
Sorry, needs to be quantified, but the quantification need not be accurate. That's
Yeah.
what the case law tells us.
Yes.
We've also got provisions that make clear that if you've made a mistake in a claim, you can make a supplementary claim within the time limit.
Yes.
Where does this factual scenario
But
sit?
if that's assuming you've made a claim,
Well,
you can't amend something if you haven't made a claim.
okay, so your position depends on saying you just haven't claimed in respect to the other tax. So
Yes.
to take your withholding tax situation, if the withholding tax was actually 3,000 rather than 2,000, you could make a supplementary.
Yes. But
anything else would be a new claim.
exactly. And if you were to say beyond the time limit for making claims, but during an inquiry, if the taxpayer were to say, look, I've now discovered or I've forgotten that I had this claim for another source of income, a double tax credit claim, they couldn't say, I've already made the claim. That would be the logic, I think, of my learned friend's position. I've already made the claim because I only need to claim DTR. And that is one claim, and it just encompasses the entirety of double tax relief. That's my learned friend's case, and therefore the taxpayer could say 4 years into the inquiry, actually, I forgot about that. You've got to take that into account in the inquiry, and the inquiry then goes on. I mean, the point I'm making is that there's a practical matter about claims. That claims have to be there so that the revenue know what they're investigating, what they're inquiring into.
And if I understand your position correctly, I think you're saying you need a separate claim for each dividend.
Each dividend, yes.
And in relation to each dividend, a separate claim in respect of withholding tax and underlying
Yes,
tax.
that's right. It seems later on in the decision, the Upper Tribunal, in a later issue, which we'll come to, the Upper Tribunal appear to accept that you need to make a separate claim for each dividend. I don't understand how that's consistent with their position on issue 3, that there is only one claim for DTR, but we'll come on to that.
You'll come back to that.
Yes, when we get to the issue. So, it's, so can I then just look at what the Upper Tribunal said about this to finish off issue 3? And it's particularly paragraphs 152 to 153. Sorry, 152 to 155. Which begins on page 177. And the key paragraph in my submission is paragraph 154, where the Upper Tribunal say we accept HMR's submission that they're entitled to know that a claim to DTR is being made and the amount which is being claimed. However, in circumstances where the provisions don't identify any additional level of detail to be included in a claim, we cannot read any further requirement into the provisions. There are various forms of DTR described in Part 18 ICTA. They're all reliefs which mitigate the effects of double taxation, whether it is juridical double taxation or economic double taxation. We agree with Mr. Brem that a claim for DTR encompasses all types of double taxation. So they do accept this point that it is everything. Hence, if a company claimed treaty relief when it ought to have claimed unilateral relief or vice versa, we cannot see anything to suggest it be denied relief because of that error. But that's a red herring really, because no one would be denied relief if they made it clear what they were claiming, the underlying tax or whatever. They wouldn't be denied relief because they've labelled it unilateral relief rather than treaty relief or vice versa. That would never be a problem. As I said, there's no requirement for you to state the statutory provision under which you're claiming. It's obviously good practice and it may make it clear what you're doing, but it's not necessary, and it wouldn't invalidate a claim that you put in the wrong section number or put it under the wrong provision. That's not the point that's the point we're making. So that's really a red herring, that point. And then say, similarly, if a company limits its claim to withholding tax when it could have claimed relief for underlying tax, there's no reason it should not make a supplementary claim which is within time. It would not need to make a new separate claim. Well, that's correct. But seems to suggest that these are separate claims.
Well,
we're talking
so
about
it says within time.
Yes, within time, but
And the revenue would accept that you could make a claim for underlying tax relief.
within time, of course. Yes, none of that. But it doesn't really meet the point.
The point here is you say effectively they're out of time to top up.
Well, we say that they haven't made the claim. They didn't make it in the return.
Yes,
and they didn't make it, and so
if they made
they're now out
it,
of time.
yeah, you say they're now out of time.
Well out of time, yeah. So they're quite a long way out of time. In this case, I think it was 2004 we're talking about. So they're about 15 years out of time. Yeah. But my point is that this doesn't really meet the point, because the point is that when you've got an inquiry, if you've made a claim, then the claim can be adjusted in the inquiry as a result of the inquiry and the closure notice, or if they don't, you can appeal it So it's a very particular situation we're in. If there was no inquiry, then of course they would have to have made a supplementary claim within time in order to be able to get the underlying tax relief.
Well, you
They
say
could- they could-
supplementary, it would be more consistent with your position to say it's a new claim.
Well, yes. But even, sorry, even, what the point I was making, my lady, was even on their case, they would have to make they'd have to amend the claim. If there was no return, sorry, if there's no inquiry open. the
Sorry,
only thing they would-
sorry to interrupt, but
Yeah.
just focusing on my lady's question, is there some magic in this context in the word supplementary? Because the UT seem to be distinguishing between a quote supplementary claim and a quote new and separate claim. And at the moment, I'm struggling to understand the distinction unless the word supplementary has some magic.
Well, it is referred to in the legislation. We mentioned it yesterday, this provision yesterday, paragraph 56.
Which allows you
Is
to,
the mistake in the claim specifically refers to supplementary claims.
Yes.
So I rather thought that
that's what they're referring to.
that's what.
But
they're
there is a
getting
claim and it's being modified if it were
at. And they
supplementary.
say within time, which is what paragraph.
Yes,
56
exactly.
requires. But we're not in that situation here. The situation you're positing is we've got an inquiry ongoing. If an inquiry is ongoing, they can in principle try to amend during the inquiry. That's the point, isn't it?
Well, they wouldn't formally amend it. They can't do that. But they would raise the matter in the inquiry,
So
and the
is
revenue would have to
this
take it
the
into
fact-
account.
Because I'm struggling a bit. You're drawing a distinction between no inquiry and an inquiry.
Yes.
Where in an inquiry situation, there has been a claim which you say is just a claim for £2,000 of withholding tax.
Yes.
Taxpayer puts his hand up and say, "Oh no, that should be 2 million." During the inquiry,
Yes. Now, we would say if you made a claim for something, say withholding tax of £2,000, and then during the inquiry you realise it actually should be £5,000 or £10,000, then that's a matter you can raise in the inquiry, and the revenue would take into account in closing the inquiry and could increase the claim to £10,000 if they are satisfied that that was right. But if you haven't made a claim at all, then you have to make the claim at some point before the revenue can take it into account. And my point is, if the taxpayer is right, then they've made a claim for all DTR. It encompasses all DTR, that's their case. And so they don't have to make any more claims in relation to other sources of income.
Am I right in understanding that on that theory, they wouldn't need to make a supplementary claim either?
In an inquiry, if there was an inquiry going on, yes. The position is different if there's no inquiry. If there's no inquiry, they would get the benefit of £2,000 of withholding tax, because that's what they put in their return. They would then have to make either a supplementary or modified claim, or a new claim if they need to make a new claim.
so your point is going back.
It's the
to
inquiry
last-
that's crucial, yeah.
Yes, so going back to the last sentence of 154.
Yeah.
That may be outside the inquiry situation, but we're addressing an inquiry situation where if the taxpayers are right, their initial claim for withholding tax, £2,000, can be enlarged, if you like, by them raising it during the inquiry
Yes,
to 2 million of underlying tax.
and as long, or any other double tax, really. Yes, exactly. Yeah,
I can understand. And
That's-
the way
that's
they
fine.
would enlarge it is by engaging the provisions that allows a taxpayer to put forward amendments during the inquiry. process. Is that
Well,
how it's
they
done?
might be out of time for that, because that's only, they can only make an amendment at all within 1 year of the
Okay.
time. What they would do is they would say to the revenue and during the inquiry, actually, look, here's our evidence, it's actually,
Oh, I see. So they would just
The
persuade
claimant-
the revenue that that's the correct tax treatment.
exactly, that's the correct amount. It goes back to the point that if you make a claim, it doesn't have to be correct to be valid.
Yes.
It can be, and during the inquiry, that's it's open to them. And if the revenue refuse, they can appeal to the tribunals on the grounds that, in fact, the claim should be 10,000 or 1 million or whatever it is. So it would have quite significant, it has quite significant consequences even today. Not, even though today we don't have problems with foreign dividends because they're all exempt pretty much. We would have the same issue in relation to all other double tax credits. Our submission is that there's nothing in the legislation that tells you that there is one claim for DTR.
And if the taxpayer were right, they wouldn't really need to do more in any case or at the relevant date and simply put a one sentence in their return saying we also claim any DTR which may be due in the appropriate amounts.
Well, that might be possible, or they could just make a claim for DTR,
Or
some
just claim
DTR.
we claim
something.
DTR, full stop, and even that would be good.
Yeah, subject, it does have to be quantified.
Well,
though,
that's what I was,
yeah.
but the quantification doesn't have to be right, so in that case you can say in such amounts as may be appropriate or something like that.
That's possible. Depends. Yeah. Depends whether that's quantification, but you could actually quantify it.
You could say, yeah, we hereby quantify
There would-
£100 or whatever.
There might well be some DTR that you know you're entitled to, so you just claim. Yeah. Yes, exactly. So that was all I was going to say about issue 3, unless there are any other questions. Issue 4, I think I can deal with pretty quickly, as did the Upper Tribunal. For those who haven't seen it, Schedule 1A is a provision which provides mechanisms for dealing with claims. Perhaps I can just show you briefly. I don't think we've actually been shown Schedule 1A. Claims which are made outside a return. It is tab 4, which begins on page 17. Yeah. I don't think we actually have. Section 42 of the Taxes Management Act is the provision which introduces a schedule.
I think it's actually,
I'm not sure.
I think it's done via Schedule 18 now, Corporations Act, rather than Section 42.
That may be wrong.
And I think we have got some provisions of
Yes,
Schedule
but
18.
but certainly Schedule 1A applies to claims not included in returns, because if it's in the return, then of course there is a whole mechanism under the return provisions for opening inquiries and inquiring into them and obtaining information, etc. So what this does is deal with claims outside the returns,
Yes.
and it has all sorts of provisions about opening inquiry, making inquiries, obtaining information, etc., closing the inquiries. It's all parallel to the provisions that you might have in relation to a return.
I see it opens with a wonderfully circular definition of claim.
Yes, exactly. But it also provides that if you look at paragraph 4, which is on page 21, it provides that in sub 1 that an officer shall, as soon as practical after a claim, give effect to the claim. However, that is subject to the later provision, which allows the inspector to open an inquiry. So if they open an inquiry, they don't have to give effect to the claim. But if they don't open an inquiry, then they're obliged to give effect to the claim. And I think that's the answer. My learned friend raised the point, well, what gives you the right to double tax relief if you make a double tax relief claim? I think the answer now, or certainly since 1998, is Schedule 1A.
Well, only if you've made it outside the return.
If you made it outside the return, if you made it inside the return, you get it under because it will be part of the return, and so it will give an effect that way.
Yeah.
So there's two ways it's given effect. I agree.
There is quite a lot of learnings that are on the scope of inquiries, and how far they should be extended as going. I don't think we have any problems of that nature in the present case, do we?
No, I don't. No. There was the inquiries is to anything in the return.
Yes. Yeah.
So they can inquire into anything.
Unless it's narrowed down in some way, which wouldn't be the case.
Yes. And so what's being said here is that there is a claim for underlying tax in the return, although you can't obviously see it.
Yeah.
It is there.
Okay, so if the revenue say we're opening an inquiry, that then puts really everything to do with that, with DTR in relation to that return.
Or claim.
Sorry,
Anything that's in the claim. Yes.
That claim.
Yeah.
Brings that into the arena
Yes.
for argument and ultimate resolution by a closure notice.
Yes. Exactly. Yes. So the point here is that Schedule 1A doesn't give you a right to claim. It applies to any situation where there is a claim. Claim is provided under the Taxes Act somewhere, and it gives you the mechanism for dealing with those claims. But it doesn't give you any right to claim anything. That's the short point. I think the learned friend accepts that on its face. I think he says somehow European law comes into play here, but I don't. In my submission, it's simply an administrative mechanism. And what the Upper Tribunal said in paragraph 163, I would say it's correct. I don't think I need to take you to it, but they simply make that point exactly. Can we then go on to issue 5, which is out of time amendment? It's an out of time amendment. And that is fidelity is the case, and the actual document is behind tab 20 in the joint supplementary bundle. That's the one. I hope you now have the letter, covering letter.
Yeah, that was handed out
Yeah.
yesterday, I think.
Now, this purports on its face to be an amendment to the return under paragraph 31. However, it's out of time. There's a 1-year time limit for making amendments. And therefore, it has no effect as an amendment to the return. It's a nullity. What it could well be construed as is a para 52 claim. I'm sorry, a para 51 claim. Not para 52, because it is a claim for repayment of tax. Rather oddly, in relation to an amendment, it is a claim. It says on its face that it's claiming repayment, and it's claiming it on the basis that the dividends are exempt. So in my submission, this puts it in exactly the same position as in issue 2. And I'm not going to repeat all the submissions I made in relation to issue 2. But there's no way that it can operate as a valid amendment in my submission. It's out of time. We know that European law says that reasonable time limits are perfectly fine. So there's no question of it being a valid amendment. this is the point where I was going to hand over to Ms. Belgrano, who's going to deal with section 114, which, as we understand, is brought into both issue 2 and issue 5.
All right.
If that's acceptable, I'll sit down.
If we reach section 114, this issue, then it means that, as my learned leader has said, the SLLM para 51 claim and or the late amendment to the fidelity returns is not, as my learned friend Mr. Bramner put it, a permissible route to recovery, i.e. one needs a claim to DTR. And if we reach this point, the para 51 claim and or the late amendment can't be construed to be the relevant DTR claim. So my learned friend Mr. Bramner's argument that the tax credits are just a mechanism for calculating the amount of UK tax chargeable has failed, and we can't do it as a matter of construction. So you need a claim for DTR credits and a para 51 claim or a late amendment, not such a claim. And it's at that stage that my learned friend says, well, 114 will permit, if there needs to be a correction, that correction to be made so the claims actually are of the correct nature. That's where 114 comes in. And I say section 114 does not apply to these claims at all. And even if I'm wrong on that, it doesn't have that effect. I have 4 main submissions, and if I may, I'll make them by reference to the text of 114 directly in the first instance before turning to the authorities. Section 114 is at tab 3 of the authorities bundle on page 13. So my first submission is that the text and context of section 114 and authority, and I'll take the court to the judicial review in Archer, decision of this court, paragraph 34, shows that a para 51 claim or a late amendment are not documents that fall within the scope of section 114 at all. This section is concerned with official documents from, if I can put it broadly, the authorities, that are documents that are required to be provided by the authorities and have a formal validity requirements and are to be used in assessing, charging, collecting and levying tax. And I'll show this court why I say assessing in this context doesn't include self-assessing. This raises my respondent's notice point because the Upper Tribunal did not hold that the para 51 claim in the late amendment couldn't fall within the scope of 114. It says at paragraph 121 of its decision, even if 114 applies to taxpayer documents, then, and it goes on to rightly hold, it wouldn't cure the defect or mistake. But in the respondent's notice, I should say it's put by reference to the SLLM para 51 claim, by reference to issue 2, because that's how the UT decided it. But paragraph 1 of the respondent's notice makes it clear we take that point on all the issues this is relevant to, so issue 5 as well. And just for the court's note, it's core bundle, tab 4, page 51. That's the respondent's notice. If I'm wrong on that, if I'm wrong on construction, and I'll come to develop it, but I'll give the court all 4 of my points so that when we're going through the authorities, I can simply pick out the relevant paragraphs. If I'm wrong on that and section 114 applies to these taxpayer documents, then we can only be looking at section 114 in relation to a want of form, which I don't understand my learned friend to be relying on at all. So more relevantly, a mistake, defect or omission that falls within the scope of 114. And my learned friend said yesterday, page 32 of the transcript, they asked for the wrong thing or they failed to ask for a DTR credit. And my submission is that where the alleged error or defect in a document conveys exactly what the author had intended to convey, that is not a mistake or defect or omission that falls within the scope of section 114. And the Upper Tribunal correctly held at paragraph 121 of its decision that this was not the sort of defect that fell within 114. Even if I'm wrong on that, and it's possible to characterise the difference between the para 51 claim or the late amendment and a DTR claim as a mistake, defect or omission, I say that mistake, defect or omission would be fundamental or gross. So in any event, section 114 could not cure that sort of a mistake. And the Upper Tribunal held the same at paragraph 121. And put shortly on this point, and this is why I say it's important to sort of focus on when we get to 114, if this court has decided as a matter of construction that that para 51 claim or the late amendment cannot be construed as a DTR claim, then I say necessarily it follows for 114 when one's asking, would it be a fundamental or gross correction? The answer must be yes. And finally, if I'm wrong even on that, any such mistake, defect or omission would have misled a reasonable officer reading the paragraph 51 claim or the late amendment, so that the person, property charged or intended to be charged or affected thereby is not designated therein according to common intent and understanding. That condition wouldn't be met, as the UT also held. So if I could turn to my first point, the text and context of section 114. If we look at the language of 114 itself and 114 sub 1, it's dealing with assessments, determinations and warrants expressly. So expressly identifying documents issued by the revenue to a taxpayer, or by the authorities in the case of warrants, so a court officer who can use a warrant to go and distrain property. So these are formal official documents directed by the authorities to a taxpayer. And in my submission there, this picks up an exchange that I think my Lady Justice Falk had with my learned friend. Assessment doesn't include self-assessment. If we look at subparagraph 2, an assessment or determination shall not be impeached or affected, and then skipping over A, by reason of any variance between the notice and the assessment or determination. And I say that's a linguistic pointer, that's talking about an assessment by the revenue and a notice of assessment by the revenue, not a self-assessment by the taxpayer.
This provision goes back at least 1970.
1918. It was originally in 1918, and we'll see in one of the cases, we'll see how it was in 1952. And it's quite interesting because paragraph 1, section 113 sub 3, which are another category of documents that the courts have construed as falling within 114, in the 1952 Income Tax Act were within the same section as these two provisions we're looking at. So it has a long history. There was sort of
to say the obvious goes back decades before self-assessment was ever dreamt of.
Absolutely, absolutely, that's right. So other proceeding, if we look at other proceedings which purport to be made in pursuance of any provision of the Taxes Act, that's generally been treated as including documents referred to in section 113 sub 3, which is in the previous tab, page 9 of the authorities bundle. So assessments, determination of penalties, duplicate warrants, notice of assessment or determination of demand, or other document required to be used in assessing, charging, collecting and levying tax. And again, just to make the point whilst we're on section 113, I make the same point about assessing. That is referring to assessing by the revenue. And if, please, the court would look at subparagraph 1 of subsection 1 of section 113, there Parliament is referring to the form of any returns under the Taxes Act which need to be in such form as the board may prescribe. So my linguistic point on the text is where Parliament, in the context of these two sections, wants to refer to a self-assessment, as we now say, that's referred to as a return. And the language in my submission points to assessment being an assessment by the revenue. So my learned friend, Mr. Bramner, said that the case law we have on this point specifically as to whether 114 encompasses taxpayer documents is McGuinness. I just need to show the tribunal the paragraph that my learned friend relies on. My submission is McGuinness is not authority, and it's not authority anyway because it's FTT. The judge in McGuinness was not saying that. I will show this court, the judge in McGuinness, some years later, the same judge, Judge Redston, decided a case called GLL, where she held in terms that 114 does not apply, as a matter of principle, to a claim made by a taxpayer. It's to do with revenue documents. So I say that's the wrong reading of McGuinness, but I can show the court also on the terms of McGuinness itself that it's the wrong reading. McGuinness is in, I believe it's volume 2, for my lords and my lady, of the authorities bundle, tab 29, page 702.
I'm so sorry, could you give me that reference again?
Yes, volume 2, tab 29, page 702.
Thank you.
So the point in this that Judge Redston
Can you
was
just
dealing-
enlighten me? I mean, this is very beside the point, and I do apologise, but I can't resist. Why is she described as presiding member when she's the sole member?
I don't know. I'm afraid I.
And it's not just on, in editing. It says the same thing at page 10 of the decision. Seems a bit baffling to me, but there we go. So, I'm sorry, that's a distraction. Let's concentrate on what matters.
Yes, so she deals with this issue on the basis that the notice to file contained a mistake as to Mrs. McGuinness's name. That's paragraph 43. She then looks at the dictionary. Definition of proceeding, the principle of justum generis, and the principle in paragraph 50 that the statutory construction is that an act should be read as a whole, before coming to the conclusion at paragraphs 52 and 53 that the documents referred to in section 113 sub 3 are encompassed in other proceeding in section 114. That's paragraph 53. And paragraph
As I understand it, you say that's correct.
the cases have generally accepted that, yes, I don't have a specific quarrel with that. And as I say, in the 1952 Act, actually those documents were within the same section as the 114 sub 1 and sub 2.
Right?
Paragraph 54 is the paragraph my learned friend Mr. Bramner particularly relies on. So for the proposition that a self-assessment provided by a taxpayer falls within the scope of 114, I say that's a wrong reading, it's a misreading. Paragraph 54 says, if this is correct, then an SA tax return would be an other proceeding, as it is a document required to be used in assessing tax. And this is the critical sentence, the next one. A notice to file takes the place of a self-assessment return for those who are expected to file online. And if I could just then pause there, the judge here is using the words SA tax return. It seems to mean the thing that taxpayers who filed on paper received instead of a notice to file. So she's not there referring to a self-assessment tax return filed by a taxpayer. She's referring to, in my submission, a document provided by the revenue which took the place of the simple notice to file if you're filing electronically. Yeah, my learned leaders helpfully reminded me it was a notice to file. I think it was, I haven't seen this myself, but it sort of had a, you must file this self-assessment. And before the internet, as I understand it, you'd have simply been sent the form to return. You wouldn't have been able to tax return. Yes.
That still happens now,
Well, yes.
at least for some, yes.
Maybe only for those who file on paper.
So that's
So
my,
your point is that it's a document emanate. The judge is referring to a document emanating from the revenue.
exactly. And she's using it as a, well, if you file electronically, it's a notice to file. If you're filing on paper, it's a self-assessment return. But both of those being documents that the revenue would send to the taxpayer to tell them to file a self-assessment, a tax return.
And of course, the mistake in that case was mistyping the name on the front of the form. that
It was a
sent.
notice to file, yes. It was mistyping a name on a notice to file. So if we could go next to this, the decision of the Court of Appeal in Archer, it's a judicial review. I believe it's volume 3 of the authorities, tab 39, page 1054.
Well, you said you were going to refer us to another decision of Judge Redstone. Is that referred to in Archer, or does it come afterwards?
It's after Archer. I was going to take a
that's fine.
chronological.
Yeah, that's logical. Thank you.
So the point in Archer that was relevant to 114, why 114 came up, was whether the closure notice that had been sent to the taxpayer was defective because it didn't set out the amount of tax for which the taxpayer was liable. And if it was invalid on that basis, whether it could be validated by 114. And the court decided it was defective. That's paragraphs 22 and 31. And therefore, the court had to turn to section 114, which it did from paragraph 32 on page 1063. So picking up at paragraph 34, here the Court of Appeal notes that the judge below held that the closure notice was an other proceeding for the purposes of 114. And Lord Justice Lewison goes on to say, it's generally accepted that the phrase other proceeding in section 114 is intended to be a shorthand reference to the kinds of documents and matters listed in section 113, which include every document required to be used in assessing, charging, collecting and levying tax. And there's a reference to McGuinness, where we've seen that that's what Judge Redstone held there. I think my learned friend Mr. Bremner said that that was confirming Judge Redstone's conclusion in McGuinness as to the scope of 114 and possibly that it applied to taxpayer documents. If I've misunderstood that, then I'm sorry. But if that submission was made, then I say, well, that's wrong. Here, what the Court of Appeal is accepting, as it were, is sort of not deciding, but accepting, generally accepting, is that those documents in 113 sub 3 are included within the scope of 114. And the Court of Appeal makes the point in the same paragraph that what it's dealing with is a defective closure notice. So that was the document being construed. And I don't think this court was taken through paragraphs 35 to 39, but actually, in terms of learning on scope of section 114, these are 4 very useful paragraphs because they collate 2 other important cases. One is my Lord Justice Henderson's decision in a case called Pipe, and the other one is the decision of the Court of Appeal in a case called Donaldson. So if we could just look at those. Paragraph 35 draws out the point against letter E that some mistakes may be too fundamental or gross to fall within section 114. And against letter F, in terms of, well, how does this court approach that? What is an error that's too fundamental or gross? The answer is given. One concentrates on the nature and effect of the omission in the particular circumstances of the case. So it's not an a priori, something that can be decided in the abstract, as it were. One looks at what is the mistake or omission, and in the context of that case, is that fundamental or gross? So here again, the starting point of my submission is critical. It's that one needs a DTR claim, and that a para 51 claim or a late amendment can't be construed as such. So without prejudice to my point that there's no mistake, defect or omission, which I'll come on to, even if that's wrong, this would be a fundamental or gross mistake. One needs to be substituting one claim, which was not made, for an entirely different one that was made, or vice versa. Another way it's been put, and we can see this from the quote of Donaldson on the same page against letter J, is whether the mistake, defect or omission was one of form or of substance. So if it is of substance, then it does not fall within 114, or put another way, it can't be cured by it. If it's one of form, then that's what section 114 is getting at. And the difference between form and substance is, for example, imagine that what the statute requires is, this actually was the Donaldson facts, one needs to be told when one receives a penalty assessment the period for which the penalties were assessed. In Donaldson, 114 cured the error, which was that the notice of assessing penalties didn't say that, because it was quite clear to the taxpayer from, I think, other documents or the context and things he'd been told already, what period those penalties were assessed for. So that's why it's of form rather than substance, because the substance that the statute requires you to know exactly what period the penalties have been assessed for has been met. Over the page 1065, one needs to ask whether the reasonable recipient, and in Donaldson, in the quote in Donaldson, the Court of Appeal refers to Mr. Donaldson not being misled by the omission or the mistake. And here, Lord Justice Lewison's saying it needs to be an objective test. So it's the objective reader of the document, but equipped with the knowledge that the actual recipient would have had. Skipping over the findings of fact that were on challenge at 37 and 38 and looking at 39, which is the court's conclusion in Archer. The court says, I don't consider that in reaching the conclusion the judge applied the long legal test. On the contrary, applying the test in Donaldson, Mr. Archer's liability could have been easily worked out, and he can have been in no doubt what he owed HMRC. He had in addition been informed by the APNs what he owed the revenue. What HMRC asserted, was his liability. He could not have been confused or misled. And skipping down a few lines, HMRC's omission to amend his return to accord with their conclusions was, in my judgment, a matter of form rather than substance on the particular facts of this case. I hold, therefore, that the closure notices were validated by section 114. And then at 40, he goes on to look at a situation where there's the notice given by the revenue doesn't match the assessment.
Can you explain to me, why does he say that he's disagreeing with the judge at 41 when the facts found by the judge are not challenged, and he says the judge applied the correct legal test? Where's the disagreement with the judge?
it was on the prior point.
I-
Whether you get to section 114 at all.
Oh, I see, right.
if I recall correctly.
I
Okay.
also, I think
I think my lady's explanation
Yes.
makes sense, yes.
whether one gets to 114. I
Okay,
also think it's that there was the judge below had held various made various conclusions as to whether a judicial review was the right route to challenging this, or whether an appeal should have been brought, and that's dealt with at 42.
yeah,
and
yeah.
There's disagreement on that. So I think there's also something
Yeah.
to do with the procedural.
So
for it.
hence the result is the same, but the
Exactly
route is
that how it
different.
should have been raised.
Yeah.
I think so.
All right.
So now DLL, which is at tab 41 of the authorities bundle. This is the second decision of Anne Redston that I need to look at. And that's at page 1082. Very briefly, to give the court the facts, the taxpayers were German real estate investment funds. They held estates in UK real estate, and the rent on properties was paid under deduction of income tax. The ultimate owners were German pension funds, and one of them was called Bayerische. In February 2014, the taxpayers wrote to the Revenue claiming repayment of income tax, and HMRC understood the claim letter to relate only to Bayerische's share of the tax, not the tax attributable to the interests of the other ultimate owners. And the Revenue issued a closure notice refusing the claim on the basis that Bayerische owner was not registered as required under the Finance Act 2004. There was an appeal. As part of the appeal, applications were made, and there were two applications that are relevant to us. The first one was the taxpayer applied to amend their grounds of appeal, as they put it, to particularise quantum, on the basis that the original claim made was for repayment of tax relating to all the beneficial owners, not just Bayerische. And as we'll see, both the FTT and the UT say, well, that's wrong. As a matter of construction, this claim for repayment was only in respect of Bayerische's share. And as a second application, the taxpayers applied to the FTT for a ruling, which the FTT took as a preliminary issue rather than a ruling, because it doesn't have jurisdiction, that section 114 TMA permitted the taxpayers to amend their claims so as to encompass the other beneficial owners. That's the second application. And that's the most relevant to us. So if we could pick up, please, at paragraph 62, just to show the point of construction. Paragraph 62 is where the page 1096 of the bundle, the FTT decides that the claim letter only related to Bayerische. So it starts to deal with the second application at paragraph 71 of its decision. Between paragraphs 77 and 84, the First-tier Tribunal sets out the case law, including at paragraph 77 its previous decision in McGuinness, that the judge's previous decision in McGuinness, and the judicial review in Archer, both in paragraph 77. At paragraph 85 sub 1, page 1101, the judge records the taxpayers' submissions, and it's little 1 and little 2 we just need to look at. Little 1, a claim for a repayment of overpaid taxes and other proceeding, because it's a document required to be used in assessing, charging, collecting and levying tax, which is essentially my learned friend's submission on para 51. And then 2, the section provided a substantive right available to both HMRC and the taxpayer, referring to Donaldson. And the judge answers those points first at paragraph 88. She says, I agree with HMRC that section 114 does not apply to claims sent by the taxpayer to HMRC. That's clear from the wording of the provision, which refers to documents used in assessing, charging, collecting and levying tax or determining a penalty. These are types of documents issued by HMRC to gather taxes. They are not documents sent by a taxpayer to HMRC when claiming a refund of overpaid tax. And if I could just pause there and add the Upper Tribunal, this goes to the Upper Tribunal and I'll show this court briefly. The Upper Tribunal decides not to decide this point. It expressly decides to leave this point open because it says there are lots of different types of documents and deciding a point like this might cause unfairness. But the reason I'm showing the court this anyway is because of my learned friend's reading of McGuinness, which, as I say is wrong on paragraph 54 of McGuinness, but this is the same judge having referred to Archer and coming to this decision, and one might have expected if she thought she was doing something completely other than she'd done in McGuinness, that she would have said that.
And of course she was free to change her mind like
Absolutely.
any judge.
Absolutely, and that's why I put it
To do so.
exactly. But she might have said, "I've changed my mind,"
Might have said.
especially since she specifically referred to McGuinness at paragraph 77, and then seems to otherwise apply it. Paragraph 89, she makes the point that the recipient would have been misled by the original document. And the reason is against line 35. An objective reading of the claim letter, the reasonable person would understand it to relate only to Bayerischer and would have been misled by the wording if the claim did in fact relate to all the investors. So again, construction's relevant to the question of misleading. Paragraph 90, she says there's been a fundamental change. 91 is, I just want to draw the court's attention to the point she makes in the last clause. I can pick it up against line 10. The applicants made explicit and detailed claims relating only to Bayerischer. They signed a declaration that the claims are correctly stated to the best of their knowledge and belief. And it was only later that they decided to seek to expand the claims to include other investors. That is not the sort of mistake which Section 114 is designed to remedy. And I rely on that. I'll show the court two other authorities that basically make that point as well. Section 114 is not dealing with a case of I've changed my mind and I wish I'd made a different claim I didn't make, which is what my learned friend needs it to deal with. So the Upper Tribunal's decision in this case is tab 44 of the authorities bundle, page 1180. And we can pick straight up at paragraph 39 on page 1195. So paragraph 39 makes the point I've just made, that the Upper Tribunal decides not to decide whether, as a matter of principle, 114 applies to documents the taxpayers send to HMRC or not. Paragraph 40, I rely on this. The Upper Tribunal makes the point that in any event, the claims for repayment for overpaid tax made by the taxpayer, this is against letter D, were not required to be used in assessing, charging, collecting and levying tax. It says that process ended well before the claim letter, and moreover there was no requirement to submit the claim letter at all. And I say that applies here. Neither the late amendment nor the Para 51 claim are documents that are required to be used in assessing, charging, collecting and levying tax.
Because a claim is optional.
A claim is optional, so is an amendment. But actually, I say the language, it goes back to my first point, that language of required to be used in assessing, etc., is really dealing with what HMRC have to do, not what a taxpayer may need to do or may want to do. Paragraph 42, just above letter G, it's a sentence beginning, having already concluded that viewed objectively, the letter claimed only repayment of a proportion of the income tax the appellants had paid, there could be no mistake in an objective sense in the letter, since the letter claimed repayment of the precise amount of tax that viewed objectively it intended to claim. And this is support for my proposition that saying that where a document precisely reflects the intention that was always there, and what's happening is a taxpayer said, I think I was wrong now, I wish I'd done something else, that's not a mistake or defect or omission that falls within the scope of 114. Paragraph 43, the Upper Tribunal makes the point that a reasonable hypothetical officer would most certainly have been confused or misled if, but by the mistake, because the claim letter only claimed on construction a proportion of the income, and if 114 permitted the claim letter to take effect as a claim for repayment of a much larger sum, that would have misled the hypothetical officer. At 44, the tribunal makes the point it's not just a matter of sort of relative quantums, but there's a core requirement to quantify a claim, and there the change, I think the change was between about 1 and 6 million. It was quite a big difference. Would have been fundamental and went to the core of that requirement. So that covers a lot of the case law ground I need to cover. I should say my efforts led me to find a case where the First-tier Tribunal applied section 114 to a claim by a taxpayer for repayment of overpaid tax. It was under Schedule 1AB, which is the analogue of Para 51. So I'll therefore give it to the court of my learned friend, but I don't actually say this assists at all for a number of reasons. First of all, in that case, the revenue, it's a case called Dugan, the revenue had accepted that a claim for relief from overpaid tax had been made, but they said it was somehow in the wrong form. Second, where the judge deals with 114, it is an assertion. It is completely unreasoned on this point. He simply says, in any event, 114 could cure any defect. I don't think there is a defect, but if there is, 114 could cure a want of form, I think it was in that case. And point 3, I say it's wrong. But just give some to the other side. So the relevant paragraphs are paragraph 6. That shows that in the income tax return, the appellant had included benefits for company cars and fuel. Paragraph 12, where the appellant informs the revenue that that was a mistake, and those were not benefits. It's a 20th of February 2014 letter. Paragraph 91, where the tribunal sets out various questions they identified, I think, and particularly 3 and 4 are the most relevant ones. What's the significance of the revenue having accepted that the 20th of February 2014 letter was accepted as a claim, but 4, was it validly made despite the revenue saying it wasn't made in the correct form? Paragraph 116 to 117, where the forms of the Schedule 1AB claims are set out. Paragraph 118, where the FTT says they think that most of the information set out in 117 was provided. Essentially, the claim complied. subparagraph 1, the revenue had accepted that a claim for overpayment relief had been made. And then 119, in our view, the claims have been made in the correct form. If necessary, we'd hold that this claim is another proceeding in 1141 so as to validate the claim for any non-perform or omission. But for the reasons I've given, I say that doesn't help this court on this one. So just coming back briefly to my second principal point, which is that a situation where the original document, as in this case, says exactly what the taxpayer intends it to say, and the taxpayer then changes their mind as to what they wish they'd done, is not a mistake, defect, or omission that in any event falls within section 114, even if I'm wrong on the construction of 114 applying to documents from the authorities. And there's just one other case that I identified as being relevant. I should say, this case I sent my learned friend Mr. Bremner on Monday. Bath and West Counties, Mr. Justice Walton So what happened here, a taxpayer sold land to the War Department. He had an option to repurchase it, repurchased it, and sold it on immediately for a much larger sum. He was assessed, and we can get this from the head note on page 1424 of the report against letter A. He was assessed under cases 3 to 8. But 2 days before the hearing of the appeal, he told the Crown for the first time that the taxpayer company, that it considered it had been engaged in an adventure in the nature of trade, dealing in land, so the assessment should have been made under case 1. So one of the questions for the court was whether an assessment under cases 3 to 8 could be changed so as to be turned into an assessment under case 1. And we'll see that the court says no. If we can pick up, please, page 1427, just to show the court, this is where it's recorded against letter E. A few days before the hearing, it emerged that the assessment under appeal should have been made under case 1. Could it be adjusted? And both sides, but the revenue accepted it should have been under case 1 once this information emerged. And this is dealt with by Mr. Justice Walton at page 1429 against letter B. And I'm sorry, before we go there, I should just show the court the legislation, which is on page 1428 between letters D, E, and F. This is section 514 sub 2 and 3 of the Income Tax Act 1952, and the relevant subsection was 2. That's the equivalent of the predecessor to 1141 that we're now looking at. So on the next page, 1429, if the court might just read between, it's halfway between A and B, but the situation is the start of the sentence up to C. Letter C. So I say if I'm wrong that 114 doesn't apply to taxpayer documents, this is the answer, and one doesn't get further. One doesn't get to say, oh, well, was the error, mistake, defect, gross, would it have misled? Because it is not the sort of error, defect, or mistake, the sort of mistake, defect, or omission that comes within 114 at all. Taxpayers precisely intended to do what they did. They now wish they'd done something other, and that is not within the scope of this section. And for the same proposition, I rely on GLL, First-tier Tribunal, paragraph 91, Upper Tribunal, paragraph 42. We've seen those. And if I could just turn to the fidelity letter, just to show the court one point that I'm not sure this court has already seen. It's the 25th of February 2013 letter. The version that was handed up has got both the covering letter and the amendments behind it, the proposed amendments behind it. So the point I wanted to draw to the court's attention, it's on what's printed as bundle page 2795. It's the first of the two amendments. If the court can see, so the left-hand column is per submitted CT 600 before the claim, and the right-hand column is per the amendment. So we can see under the heading income, 3 lines down, Schedule D Case 5 overseas income. In the left-hand column, it's brought in as income, the 177,000. And in the right-hand column, it's been removed. That's because exemption's been claimed. And even more starkly, as it were, if one looks against the first hole punch, one can see an amount of double tax relief of 21,861 that was in the submitted CT 600. That was for withholding tax. And in the right-hand column, per this amendment, nothing. And the same is shown by the reconciliation at the bottom of that page. And the same point can be made on the amended computation for the 28th of February 2010 period on the next page. The income comes out of charge and double tax relief is removed. So my point is, if one gets to the stage of asking, well, was the mistake that was made here, assuming one needs a DTR claim, fundamental or gross, and would it have misled an officer? My answer is plainly yes. And I won't repeat, but the court has discussed with my learned leader, Mr. Ewart, fundamental differences between exemption claims and DTR claims. So grossing up of incomes required for DTR claims. There are different time limits. And as my learned leader said, it's no answer to my learned friend's point to say, oh, well, economically, doesn't it come to the same thing? That doesn't mean they're the same claim. And there was an exchange with my learned leader and Lord Justice Arnold as well yesterday, saying EU law isn't saying they're the same claim or equivalent. They're saying they're unobjectionable in the same way. That's nothing to the point if one hasn't made a DTR claim. The fact that computationally, as it happens, you might have got there some other way by a Para 51 claim is completely irrelevant for 114. And I should also say, this came out of an exchange yesterday with my Lady Justice Falk. In any case, I wasn't sure that submission was consistent with my learned friend's case on youth and issue 8. Whereas as my Lady Justice Falk, as I understood the point my lady was making, is that actually the taxpayers saying they get a result better than exemption in a way, because the FNR then generates youth and extra credits and all the rest of it. So I wasn't actually sure that I say, of course, as my learned leader has explained, we say the revenue's position is that's wrong. But my learned friend's case on 114, that, well, this all comes to the same computational figure, that seems to be his main point as to why it's not a gross error, is actually inconsistent with his case, as I understand it. Right, and the final point is I think my learned friend also relied on the revenue's responses in some way. I think he puts it as broadly as HMRC were not misled, these taxpayers are trying to assert EU rights. But if the court actually looks at the responses, and I'll simply give the court the references, one of them is at supplementary bundle tab 4, page 43, that's the response to the SLMM claim. It says, I acknowledge receipt of the mistake relief claims. Well, that's what they were, mistake relief claims. It doesn't say I acknowledge receipt of your DTR claims. HMRC's response to the fidelity amended returns, core bundle, FTT decision, FTT decision, paragraph 90, subparagraph 62, I acknowledge receipt of your amended figures. So again, not I acknowledge receipt of your DTR claims. Unless I can assist the court further.
No, thank you.
Now I'm going to move on to issue 7. I'll come back to issue 6 because issue 7 is another procedural issue. But in looking at issue 7, we do have to look at section 806, subsection 2. So if we could turn that up, it's in page 105 of the authority bundle, tab 7, volume 1. (806) subsection 1 provides the basic limitation period for making claims, which for companies is 6 years after the end of the accounting period, or if later, 1 year after the end of the accounting period in which the foreign tax is paid. Subsection 2 then deals with situations where things have changed, and this all comes out of the basis of the imputation system, where your claim for double tax relief is limited by 2 things. One is the amount of UK tax payable. You can only claim up to that. And secondly is the amount of foreign tax payable. You can only claim up to the amount of that. And subsection 2 is dealing with situations where either the amount of UK tax changes or the amount of foreign tax changes subsequently, and gives an extended time limit in order to allow both the revenue to make assessments to recover tax, if that's appropriate, or the taxpayer to make claims. So a very simple example would be a case where there is 100 of UK tax and it was thought that there was only 50 of foreign tax. When they made the original claim, they claimed 50. It subsequently transpired due to things that happened in the foreign country, the revenue there made assessments or claimed more tax, that it turned out that there was 100 of foreign tax. This allows you to make a claim for the other 50 of foreign tax against the UK tax. And conversely, it would also apply if the UK tax increased and you had enough foreign tax to cover the increased amount of UK tax. You could make a claim to cover the UK tax. And it's all in terms of tax payable, as I think my learned friend said. Now, this is relevant to issue 7 because what happened in issue 7 was the revenue, the taxpayer had claimed in his return, had returned the EU dividends as exempt, but the non-EU dividends as taxable. There was a period in which advisors seemed to consider there was a distinction between non-EU and EU dividends in that respect, and that European law didn't apply in some way to the non-EU dividends, but it doesn't really matter. But that was what was thought, and so that was the position. When it came to the closure notice, the revenue amended the EU dividends to be taxable from being exempt, but they didn't do anything to the non-EU dividends because they had already been returned as taxable. Now, it's accepted, of course, that section 806(2) applies to the EU dividends, because this is a situation where the amount of credit has been rendered insufficient by reason of the adjustment of the amount of tax payable in the United Kingdom. Because the result of this amendment by the revenue is that tax was payable on the dividends, because they've been changed from being exempt to being taxable. And so the amount of credit is rendered excessive, because of course no credit would have been claimed when they could be claimed when the dividends were exempt, as they were returned originally. So the result of this is, for the EU dividends, is that this engages 8062. The question is whether it also engages 8062 in relation to the non-EU dividends, where there was no change. And I think the argument here is that this is going back to the point that there is one claim, and as a result, there has been credit has been rendered insufficient in relation to the EU dividends, but that allows you to claim credit in relation to to make an out-of-time claim in relation to the non-EU dividends. Our answer to that is, I think, as my lady's already anticipated, that there has to be there's a separate claim for each dividend, EU and non-EU.
This really goes with your argument on issue 3.
Yes. But I think there is another point, which is that even if it's right, even if they're going down the line that there are not separate claims, that there isn't, the causal link doesn't apply, because there isn't an insufficiency. That insufficiency which they are claiming in relation to the non-EU dividends does not arise from any adjustment to the amount of tax payable in the UK, because the adjustment was in respect of the EU dividends, not the non-EU dividends. So in a sense, it may not matter on this issue what the correct analysis is as to claims. And can I just show you what the Upper Tribunal said about that? It's paragraphs 204 to 207. And so 204 records the revenues case that's necessary for each dividend separately, because each dividend requires a separate calculation and claim to DTR. The fact there was some adjustment to tax when the return was amended does not mean the claim can be made relying on the extended time limit, whether it be dividend income or non-dividend income. And then the taxpayers case is recorded in 205. And in 206, the Tribunal says, we agree with HMRC submissions. It's clear from 795 and C and 6 that credits are calculated separately by reference to each foreign dividend. On its terms, the extended time limit applies only to an assessment or claim to which the adjustment gives rise. There must therefore be a causal connection between the adjustment and the claim which can be made following the adjustment. There is no connection between the adjustment to the tax payable in respect to EU dividends and the lead appeal and the claim for relief in respect of non-EU dividends. The taxpayer's argument gives no meaning to the requirement for the additional claim to be one to which the adjustment gives rise. This is where I said it appeared, on one reading anyway, that the UT was accepting that each dividend required a separate claim to DTR. They do say they agree with HMRC's submissions. So we say that there are essentially two reasons, although they may come to the same thing, as to why the taxpayer's case is wrong on issue 7. Then the next procedural issue is issue 9, and that arose from the situation in which the taxpayer amended its return, but during an inquiry. So a taxpayer, as I'm sure you'll all be aware, including individual taxpayers, can amend their self-assessment returns up to a year after the relevant date, and that amendment effectively rewrites the tax return. So it would have the effect, if you were to amend your return within time, the effect would be to change the self-assessment so to what it would be under the amendment. So if you say that in your return that you're liable to £100,000 of tax, but you then amend it with the effect that you're liable to 50,000, then 50,000 will be your liability under the self-assessment. Of course, that's all subject to the revenue inquiring into it and changing it, but that would be the position until they did that. And so paragraph 31 of Schedule 18, which, as I think my lady pointed out, is correctly set out in paragraph 2, 3, 4 of the Upper Tribunal decision. Tells you what happens if a company makes an amendment during an inquiry, when an inquiry is in progress. Subsection 2 says the amendment doesn't restrict the scope of the inquiry, so the revenue can still inquire into the things that have been amended, I think is what's being said there, but maybe taken into account in the inquiry. And then, so far as the amendment affects the amount stated in the company's self-assessment, or any amount that affects the tax payable by the company for another accounting period, tax liability for any accounting period of another company, it does not take effect while the inquiry is in progress in relation to any matter to which the amendment relates, or which is affected by the amendment. So that means that the self-assessment in this context would not be changed by the amendment during the inquiry. But what then happens is, it takes effect as follows under subsection 4, and it's B we're looking at in this case, because there was an amendment in the return arising from the inquiry. In this case, the amendment takes effect as part of the amendments made by the closure notice. As I understand it, the taxpayers' case is, what this means is that at the end of the inquiry, just before the closure notice, the amendment is given effect rather than taking effect, but given effect, and so the self-assessment then moves, but then the revenues closure notice says we don't accept the amendment, and therefore it then moves the other way. So what they say is that their amendment to claim exemption did take effect just before the closure notice said no, it's not exemption. The dividend income is actually taxable, which everyone accepts is true, is correct. In fact, the dividend income, as the law stands, is taxable. So that seems to be their case, and this is why we talk about the scintilla temporis. There is sort of a moment when the dividends are exempt, and then they are made to be taxable, and that's how they get into, they say, into 8062, because there is an adjustment. Now we say that that doesn't happen, that the amendment takes effect as part of the amendments made by the closure notice. So not before the amendments made by the closure notice, but as part of them. So it's taken into account. It takes effect, you see, so far as it's consistent with what revenue have done in the closure notice. As in the closure notice, in this case, the revenue, as in a number of cases, the revenue would say, we don't think the amendment, what they've done in the amendment is correct, and therefore we're going to leave the return and the self-assessment as it is. That's broadly what they would say, and we would say the effect of that is simply there never was a time when the amendment took effect in the sense that the dividend income was exempt and then became taxable. It's simply all part of one process.
I understand what you say on the wording of the legislation, but it does lead to an odd result, doesn't it? Because you accept under issue 1 that if an in-time amendment was made without there being an inquiry to treat the income as exempt, then 8062 will allow
Yes.
credits later. The difference, and only difference between that issue and this in terms of the facts, is that by the time the amendment has been made, an inquiry has been raised.
Yeah.
And under the original version of the legislation, at least, not the one we're looking at now, that could have been an inquiry into absolutely anything. Could be a completely unrelated inquiry.
Yeah, yeah. Well,
So
it wouldn't have been. It couldn't be into an amendment because it hadn't happened yet. Obviously.
no,
Yeah.
but I'm making the point that on the facts, of course, the inquiries are actually related to the
Yes, but they don't have to be.
law issues. So whether you can achieve the result in the consequence, if you're right, is that whether you can achieve the result in issue 1 that's agreed in issue 1 may depend on the happenstance of whether the inquiry was opened, or would depend on the happenstance of the timing of opening the inquiry. That does lead me to think about whether one should perhaps give this slightly more purposive interpretation.
Can I say this, that it's no more odd than the fact that if you make a claim on one day, you're within time and it's valid, and if you make it the next day, you're out of time.
No, but
I mean, that's the effect of the legislation.
Well, but that's fine where you've got clearly available time limits. Here, they are acting within time limits. They don't know when the inquiry letter is going to land on their doorstep.
They presumably know by the time they make the amendment, so there's an inquiry open.
Yes, but
It didn't happen on the same day or anything.
They don't know how quickly that inquiry is coming, and they're still making their amendments
But
during the 1 year period.
What's clear from para 31 is that Parliament did not intend you to be able to alter the self-assessment by an amendment once an inquiry was open. We can see that.
I agree that. Yes, it's suspended, but the question
Yes.
is what happens when you close the inquiry?
And when you close the inquiry, in practical terms, of course, in a case like this, nothing happens to those dividends because the effect of the closure notice is they remain taxable. So it wouldn't matter. This is dancing on the angels dancing ahead of a pin and not Section 8062.
We can argue who's dancing on what pin, but
well, as far as there would be no question in a normal case of a change. Of a change to exemption and then a change to taxability in any sense at all. All that would happen is, it happens in any case, is a closure notice would be issued saying these dividends are taxable. We don't agree with what was being put forward in the amendment. There would be nothing would happen which would suggest that they became exempt for a second and then became taxable. So in a sense, the taxpayer is trying to get within Section 8062. Now, we have to accept in some cases where they were returned as exempt that they do get within it.
I'm not going to make the point again. You've accepted that substantial numbers presumably do get within 8062 if they happen to amend before an inquiry was opened.
Or if they returned them as exempt in the first place. Yes. Yes. But that's... I'm not saying that is a meritorious position. I'm saying that's just the result of the application of Section 8062. Domestic legislation applies. I mean, it's not, one might say it's not entirely within the purpose of Section 8062, but that's, it applies, there's no doubt. It applies. It's not the kind of situation that 8062 obviously was designed for, but it falls within its clear wording.
Thank you.
And just for completeness, the Upper Tribunal, you'll find their reasoning, well, it's paragraphs 241 to 244. We would endorse that. Can I then just deal with, while we're on procedural matters, before I turn back to issue 6, deal with what is now issue, which is issue A. I'll say a little bit about that. This was an important issue of principle below. The way it arose was because in the Avon case, which was issue 12, which is no longer under appeal, in that case, the taxpayer was arguing that there should be a closure notice, because it was a closure notice application under paragraph 33. But not only could the tribunal direct a closure notice, but they could also direct how the revenue were to close the inquiry, because that was part of their argument on issue 12. They wanted it to be closed on a particular basis, and that was the argument. And it would be obvious to everyone that that is an extremely important point. If the tribunal has jurisdiction not only to direct a closure notice be issued within a certain time under paragraph 33, but also how the closure notice is to be, what the form is to take and what the revenue can do, that would be an enormous change. We say there's just no scope for that within para 33. All it says, I'll just take you to it briefly. Yes, it's within tab 10, and it's on page 150. Within tab 10, the company may apply to the tribunal for a direction that in the revenue give a closure notice within a specified period, etc. The tribunal shall give a direction unless satisfied that the inland revenue have reasonable grounds for not giving a closure notice within a specified period. It seems pretty clear. What the taxpayer had been relying on were the cases, one of which I've shown you already, Vodafone 2, and another recent case, Eastern Power Network in the Court of Appeal, which are applying which establish the principle that on a closure notice application, the tribunal and the courts then can decide a legal point, which is if you like a knockout blow, that means that the inquiry cannot continue because there's no legal basis for it. That was what happened in Vodafone 2, if you remember. The taxpayer was saying, we have a knockout blow, the CFC provisions are unlawful under European law, you can't carry on this inquiry because all you're inquiring into is CFC, and you can't impose a charge. That was their argument, and the Court of Appeal accepted that that was a possible argument that they could bring, and the tribunal had jurisdiction to do that. And that happened also in Eastern Power Network. Now, that's not to say that that's not saying that the courts can direct what the closure notice should say. That's simply saying it can decide to direct a closure notice in a circumstance where it can see that the revenue has no case. What the closure notice says is a matter for the revenue. Now, obviously, if the revenue in a case like Vodafone 2, if it had been decided by the Court of Appeal that the CFC legislation was invalid, following a reference, and the revenue had closed the inquiry on the basis it was valid, then obviously that would have been dealt with pretty summarily. But there is no jurisdiction in the court to say to the revenue, you must close on a particular basis.
Jurisdiction to the FTT.
To the FTT or the Court on Appeal.
Yes, but we're restricted by the FTT's jurisdiction.
Exactly, yes. So there's no jurisdiction for the court on, yeah. What I understand now to be, though, I think the case is more restricted than that. So I understand my learned friend. He's not saying they can direct them. What he's raising is a question of how far decisions made in the closure notice application are binding thereafter. Now, this was a point that was raised in argument in Eastern Power Network. And if I can just show you briefly what was said about it right at the end of the decision. It's authorities bundle. It's tab 47, which I think is that in bundle 3. bundle 4. Note here. I don't think I need to trouble you with the arguments in this case. The taxpayers' case failed, and there was no closure notice provided. But and Lady Justice Rose made some comments. I'm looking at page 1313 to 1314. Made some comments at the end about how this had resulted in in the end, an enormous delay in the inquiry. She was discouraging taxpayers from bringing closure notice applications on this kind of basis. But then, if you look at paragraph 56, the approach adopted in this application has also required the tribunals and this court to apply the statutory provision in the absence of any clear findings of fact about the scheme as a whole, without any agreed statement of facts. We raised with the parties at the hearing what would have been the position if the FT had decided the arrangements did potentially fall within 146B, and the appellants had later brought a substantive appeal before the FTT against the amendment to the returns. What would be the status of the FTT's decision on this legal point when the same issue came to be debated in the substantive appeal once all the facts were known? The discussion quickly ran into the choppy waters of legal precedents and issue estoppel. I think I said, well, it rather depends on the nature of the decision. If there's a legal decision decided by, for instance, the Court of Appeal on a closure notice application, that would be binding on the First-tier Tribunal as a matter of normal stare decisis when they decided the substantive appeal.
And possibly issue estoppel.
Well, the question of issue estoppel might arise if it was a decision of the FTT and then a further FTT, although there are difficulties with issue estoppel in tax, because I think, as my lord has pointed out in a number of cases, that there is a venerable principle of tax law that each year is separate and there's no issue estoppel between different tax years. And whether there would be an issue estoppel in this kind of case, in my submission, is perhaps a difficult question. But it seems to me that these are questions that ought to be decided not in the abstract today in this case, but in a case where they actually matter. Because as far as I understand it, there is no issue in this case
So,
about.
Is this issue live then or not? Issue A?
Well, issue 8, it's under appeal. I mean, what was decided by the the Upper Tribunal was there's no jurisdiction to direct what you do in a closure notice, what the revenue does in a closure notice. And as I understand it, that's not the argument that's being raised anymore. So it's unclear as to what the position is.
Are you suggesting we should say, in effect, there may be jurisdiction, but if, even assuming it to be the case, this is not the occasion for us to answer the question because there's no live issue?
Well, I think you might say, well, it's maybe what Lady Justice Rose said.
Yeah.
We're not going to enter into the choppy waters of issue estoppel in this case where it doesn't arise. It is a difficult issue. I know from experience in other cases, and particularly so, as I say, in the context of tax, because what if the closure notice referred only to some periods, and then the substantive appeals refer to other periods, and release in other periods where there wouldn't be under normal tax rules or issue estoppel.
I'd certainly agree it's a difficult area, and that was, I think it was in the Littlewoods case.
Yes.
For instance, where I went into it at some length without coming to any very big conclusions.
Exactly, and there's been something said on it in FII in the Supreme Court and
Yes.
in 2 of the cases. So anyway, that's what all I'm going to say about issue A. Now I'm going to go back to issue 6 now. I've already taken you to section 8062. Our submissions are very simple on this, that there is no increase. If we just go back to 8062. The credit is not rendered excessive or insufficient, not rendered insufficient by reason of any adjustment in the amount of any tax payable either in the United Kingdom or under the laws of any other territory. As I understand it, my learned friend's case is entirely based on the proposition that the effect of the conforming interpretation and the EU law decision is that in some way it is treated as if, or deemed to be, tax tax is payable at a higher rate under the FNR. And I've already made my submissions when we were looking at the case law, but that is not what either the European Court was saying or what my Lord was saying in Prudential and giving a conforming interpretation. Mr. Justice Henderson, as he was then, was not saying there is deemed to be foreign tax payable at the FNR rate or anything like that.
And absent any deeming,
Sorry?
it's obviously an impossible contention because there was no tax charged at the FNR. It's a kind of notional construct.
Exactly. What you were saying is there's a dual credit. One is a credit for tax actually payable, paid, or
The tax that would have been payable had there been a charge to tax imposed at the FNR.
a credit.
Oh, sorry.
A credit computed at the FNR.
FNR, yes.
Yes, exactly. And that's a different conceptual thing. If you were regarding the FNR as a sort of deemed tax payable at a higher rate, all you needed to say was the amount of tax payable or deemed to be payable, whichever is the higher. What's the higher? But that's simply not what anything of this was about. My submission. And in any event, it's clear that it cannot be tax payable under the laws of the other territory. All of this is happening under UK law. If there is a deeming, it's a deeming under UK law. So there's nothing under the laws of any other territory. And it's not, yeah. So we say that's simply hopeless, and under issue 6, and 806.2 doesn't apply in this case. I mean, 806.2 fundamentally is not about situations where taxpayers have made a mistake as to how to compute the amount of credit, or a legal mistake as to whether credit is available. It's where circumstances have changed in the way that are set out in 806.2. Essentially, that the tax payable in either the UK or the foreign state have changed due to circumstances that have occurred subsequently.
Yes, I mean, I was trying to think this through. If the taxpayer's argument is right, there's an element of sort of self-perpetuating time limit, isn't there? Once you've worked out what your mistake is.
In a case like that, yes, yeah.
You can extend the time. I mean, I know the case is put on the basis of 6 years from.
Well, I think it's put on the basis of 6 years from the Supreme Court decision, which was in 2018.
Or possibly CJEU too. I understand that, but nevertheless, there's an element here of the taxpayer realises that there is actually a claim, and now has time to make it.
Yes, if they didn't realise there was a claim, but that's not what this provision is about. It's not about situations where you didn't realise there was a claim originally, and you now realise there is one, because nothing's changed. Nothing's changed about the amount of UK tax or foreign tax payable. That's not what 806.2 is about. It's not about where you haven't understood the law, let's say, and therefore not made a claim. Or even a situation where you made a mistake as to the amount of tax that was payable, not because there was any change, but simply because you made a mistake about the tax payable. Some arithmetical error or something like that. So then, can I turn then on to issue 8? And this is where we get to UFT, so I'm looking forward to that. Can my learned friend is taking you to these provisions. Can I take you to the youth provisions, which if you've got 806 open, it's actually the next page. If you just turn over the page, 806A. It seems to me that this raises 2 points. One is the point we've just been discussing as to whether there is a change in the tax payable, or sorry, what is the tax payable, and secondly, whether the FNR credit can go beyond the UK tax charge, which is something that I addressed yesterday. Our case, of course, is that it can't, for the reasons that I explained yesterday. So if we just look at the two cases which are set out on page 107, case A, the amount of credit for foreign tax, which under any arrangements would, apart from 797, be allowable against corporation tax in respect of the dividend, exceeds the amount of the credit for foreign tax, which under the arrangement is allowed against corporation tax in respect of the dividend. So the amount of foreign credit for foreign tax, and now foreign tax is one of the things that are defined, dealt with in 792 subsection 1. Turn back in the bundle, so I'll just give you the it's on page 46. And you see foreign tax is defined as, in relation to any territory, any tax chargeable under the laws of that territory for which credit may be allowed under the arrangements. So the same point, perhaps with even greater force, applies to this, that there isn't foreign tax payable under the laws of any other territory as a result of the FNR credit. So we say you simply don't get into case A, because the amount of foreign tax payable would be the actual amount of foreign tax payable, and presumably any claim for youth would have been made on that basis. And similarly, if we look under case B, first of all, there's a reference to with the amount of tax which by virtue of any arrangement is supposed to be taken into account, as mentioned in 7991. And if we turn back to 7991, which is on page 68, you will see there are two references. There is a reference first to where, in the case of any dividend arrangements, providing for underlying tax to be taken into account. And if we just go back to 7921, sorry, that's the definition, you will see that underlying tax in relation to any dividend, tax which is not chargeable in respect of that dividend directly or by deduction. So again, we're looking at tax, but then it goes on to say, is taken into account considering whether, if any, the credit should be allowed in the United Kingdom against respect to the dividend. The tax to be taken into account by virtue of that provision shall be so much of the foreign tax borne on the relevant profits by the body corporate paying the dividend as, and then is properly attributable to a proportion, etc. And again, foreign tax, you've seen the definition of that. So what we're dealing with here, the FNR is not going to be taken into account as mentioned in 7991 because of the various definitions of foreign tax. It can't fall within
You say
7991.
it can't. It could and would if a conforming interpretation required it to be.
If it required it to be,
So
yes.
that's the thrust of the submission, is that the conforming interpretation requires us to apply these.
I think,
provisions. I think this is probably answered by your second.
yes, yeah.
You would say it's answered by the second.
Well, I think there is another point. I mean, there are two ways you might get into this. One is if it is necessary to comply with EU law to give a conforming interpretation to these provisions. Now, I don't understand that to be taxpayers' case, and indeed it's difficult to see how there is any EU law problem with the UFT provisions. Any EU law problem has been cured by the FNR and being allowed to carry it forward under the Salonen case. There is no separate EU law problem here. As I understand my learned friend's case, it's not that. He simply says, once you've decided on the conforming construction, it's now part of UK law, and you therefore have to apply it in a normal way to other parts of the tax system. So the conforming interpretation, but he says the conforming interpretation results in more foreign tax being payable. It's the same point as under issue 6. So if that's right, then he says you plug that into this provisions which talk about foreign tax payable, and therefore it all applies. So it's not an EU law challenge, I think, that's being brought. It's saying, well, you know, it just happens that you've got a conforming interpretation, it's part of UK law, and therefore it applies across here. But the
statements in the case is to the effect that once you have done your conforming interpretation, everything else applies as normal. And I think the dispute is over what that essentially,
yes.
what consequences of that are. What
Well,
that means.
Well, the first point is that what the conforming interpretation is.
Yeah.
Because if the conforming interpretation is what we say it is, it just provides a credit computed at the FNR, then it doesn't plug into these provisions in any way, because that's not foreign tax payable. The foreign tax payable was the actual foreign tax payable under the laws of the foreign state. So the first step is he has to show that the conforming construction increases foreign tax payable. That's the point under issue 6 as well. It needs to establish. So that needs to be established, and then you plug it in here. That and that's what happened in relation. There's a slightly different position in relation to the Prudential and the EFII case that my friend took you to, because of course these provisions had to be something had to be applied to comply with EU law to allow the dividends to be passed up. First of all, through the foreign companies, because we were dealing with cases where there was a network of foreign companies, and dividends had to be passed up through the mixer into the UK. So something had to be in place, otherwise EU law would be the FNR would not be doing what it needed to, which was to get to the UK company. So those provisions something had to be applied, and what the court said was
equivalent to 801, where the
801 will.
average for
We needed it. We need something, yes, and they said 801 adapted would be the what you need.
Yes, but
Same.
I suppose that's my point. It's going back to you do what is a question of just doing what you need to do to comply with EU law
Yes,
and not more.
exactly. And I don't understand to be any argument that you need to do this in relation to 806 and the youth provisions in order to comply with EU law. And the same point goes with the Prudential and the ACT. There had to be a system. There had to be something which moved the credit from the water's edge company up to the top company, which paid the dividends out to the shareholders. Because that, of course, is where the ACT was actually paid in VAT. And there was an issue in the second reference about what the effect was of that. I don't know if you might remember, as to whether there was an unlawful charge at the top company. And they said, yes, there was. But of course, to get there, you had to have a system to move the credits, which didn't exist in terms in the actual legislation. And it was more complicated than that because, of course, ACT could be surrendered to other companies in the group, and there was all sorts of issues about computational issues and difficulties about that. But that was all required in order to comply with EU law, whereas this in my submission isn't. And of course, there is also the point that that the credit that's being given, even if it is deemed to be tax payable, is only up to the amount of UK tax. But we say you don't even need to get that far because it's quite clear these
Yes,
provisions.
that,
wouldn't apply.
for that, you relied, if I recall correctly, you relied yesterday on CJEU2 and the description of the computation system.
Exactly.
That's the authority you rely on.
That's what I rely on for that point. Yes, I wasn't going to repeat all that because
I just wanted
I think
to
I've dealt with.
clarify.
I hope I've dealt with it when we went through CJEU2. So, sorry. So those are the points we make on issue 8, and the next issue is issue 10. And the question that arises, I think, here is whether there must be an in-time claim for DTR in year 1 in order to carry forward under the sort of Salonen principles. I understand. I think it's accepted by my own friend that there has to be a claim in either in one of the years at least, either year 1 or the year in which it is applied.
Yeah, and year 2, the so-called year 2 could be
Year 2, yes, it could be
many
year
years-
5.
Could be many years later.
Yeah, 15, in fact. Yes, in the case of AXA. Yeah, 20, I think it was. Can I just then take you to what the Upper Tribunal said about this? It's paragraphs 246 to 258. And it's in particular paragraph 256 on page 194. Where they say, we accept HMRC's submission that it's still necessary for the taxpayer to have an in-time claim for DTR in order to carry forward unused DTR credits. The domestic legislation requires a claim and is implicit in sections 788 and 790 that the claim must be made in relation to the accounting period in which the dividend is taxable. The judgment in FII Supreme Court 3 was in the context of a claim for unjust enrichment. As such, you do not have to consider whether a claim to DTR was necessary for the purposes of obtaining statutory relief. In order to obtain statutory relief, there must be a claim for DTR before any unused relief can be carried forward. As discussed in relation to issue 2.4, it's clear from Class 8 that it's no answer for the taxpayer to say that it could not have known that it had to make a claim for DTR credit because no one contemplated relief for credit at the FNR, or indeed that such relief could be carried forward and offset against general income in future years. And could I add to that is supported by the decision in AXA, which I referred to yesterday, which actually is about this very issue of carry forward. Now, it's not about whether a claim had to be made, but the point there was that the claim, a statutory claim, but the point there was they had to they had to plead correctly the claim as a matter of English domestic pleading, despite the fact that at the time when they made their claims and even subsequently when they were amending them, no one could have known in the same way that Salinan was going to be decided the way it was and FII Supreme Court 3 were going to be decided the way they were. So it wasn't an answer to the pleading point that we couldn't ken. So in my submission, that's the answer here. It has to be a claim. In order to bring FNR into existence, there has to be a claim for double tax relief in the first year.
I mean, of course, the slight issue here, an issue here is the UK domestic system legislation obviously doesn't contemplate that DTR could be carried forward. So
No.
although it's all, everyone accepts that there needs to be a claim for DTR, it's pretty obvious that the domestic system would
Didn't
only
provide for it.
require the claim to be in year one because that's the only year that it contemplates is
Yeah.
relevant.
No, I
So
accept that.
here you are doing a bit of reading in, aren't you, in the sense of, you know, the question, once you do your conforming interpretation to allow the carry forward, you have got to ask yourself, how should the tax system be interpreted? When should the claim be treated as required?
Yes.
So the answer doesn't.
Well, except that yeah, that's right. One response might be that what the Supreme Court said in Supreme Court 3 was that they are disapplying the prohibition on carrying forward excess DTR. So having done that, that still leaves the question as to how you have established the DTR. Now, I quite agree that nobody would have thought of this, and that there are no provisions for carrying it forward. That was part of the argument. I mean, what the revenue was saying was it would seem easier to provide for a carry forward of management expenses, because we do have a provisions for carrying forward management expenses, but the Supreme Court rejected that. They said, as a matter of principle, it has to be the DTR that's carried forward.
I mean, in a sense, how would you answer this from first principle? Does one get any help from first principles as to the year in which the claim must be made?
Well, let's think about it this way. Supposing everybody knew about the situation, and we still had, after that had all been decided, we still had the imputation system. I know that we don't. And so this point still continued to arise. How would you think that it ought to happen as a matter of first principles? Well, you would assume, wouldn't you, that the first principles, there would have to be a claim for the DTR. I'm assuming we're looking at periods after this has all been decided.
Yeah.
How would somebody think it through? They would think, well, there has to be a claim for the DTR in order to be something for them to carry forward. If we're carrying forward the DTR and we're disapplying the provisions that prevent the DTR carrying forward, there ought to be, the answer ought to be from first principles that there ought to be a claim for the DTR. It's then carried forward, and at some point it will be brought into your tax return, presumably, and set against income, whatever income there is.
Yes, one possible reading of SC3 is that the set-off in later years, we may even have discussed this in AXA, looks pretty automatic.
Well, that,
and
in my submission, that's what it, yes, it does.
Against other income, not just dividend income.
Yes. So it's not a taxpayer choice. It carries forward until it hits
I think that
income.
that appears to be what SC3
They're saying, as
says.
far as they're prescribing some kind
Well,
of
they're not, obviously,
system.
they're not, it's quite obvious, they're not thinking about procedural mechanisms.
No, although they would have been to some extent, because we did make the point that there are no rules to carry forward DTR, and that we showed them obviously there are rules about carrying forward management expenses. So they, you know, procedural points were there, but I agree they weren't considering precisely how the procedural rules would apply. It wasn't relevant to them. I agree, but that really is my answer. The problem all arises simply because it happened before. This is events that happened before everyone knew about all of this. And it really goes back to the question, well, does that make any difference? If you would say after the event, after things were discovered, the procedure ought to be claiming DTR because that makes sense in year one and then carrying it forward. Is there any reason why that, under European law, why that should be different in years when you didn't know about it? Okay, and the kind of thrust of European law seems to be it shouldn't make any difference because there's no principle that you sort of take account of what people knew or when they knew about the law.
Yes, there's no requirement in EU law that people should know what the Court of Justice is going to decide.
Yes. And there's no
they can
requirement.
make their claims and find out.
Yeah, I think that's right. I mean, they could have gone down that route. They could have, I imagine, they can probably do anything. They could have gone down the route to say, well, you know, limitation periods are suspended until we've made a judgment or whatever. But that would have obviously...
Or going back to the first ruling, as I pointed out on day one, they could have said, this is prospective only. And they were asked that question, and they said no.
Yes. Yeah, they could have done these things, but they haven't. They've taken the simple view, I think, as a view that what they decide is retrospective in the normal way of any court, and that has to be applied.
Yeah.
Could it be said in some way, I haven't really formulated this in my mind, that what the EU principle, having settled on the FNR solution, must require is that there is to be a carry forward automatically in the absence of any specified procedure in domestic legislation. In which case you don't need any claim because actually the substance of the right sort of involves it being carried forward until it's exhausted.
I suppose that raises the question. Yes, raises the question: what are you carrying forward?
Well, what are you carrying forward? I know, but it gets very circular.
When is that fixed?
But to give effect to the carry forward, you know, you've got to assume that whatever machinery is needed for that purpose is in existence, because otherwise it becomes self-defeating. So there's nothing to carry forward anyway.
Yes, but I think that really leads to the conclusion that you would effectively make the claim at the time when you were utilising it.
If you need a claim at all on this reading, I mean, or is it just, well, I suppose you
do need some claim, but you need to tell the revenue what you're doing, otherwise nobody would
want to know what you're settling against. They need to know that, but it maybe you only need to specify a claim of that nature as well in year two, effectively, not in year one. Because year one, it's sort of inherent in the relief provided by the ECJ. It's just got to be some machinery in place, and if there isn't, you have to hypothesize it.
But that sort of goes against the structure that you do have to claim, which I think is DTR in order for it to exist and to therefore be carried forward.
That's the starting point. That's the general position. But like all rules, one has to. I mean, this may be an instance where an exception has to be crafted in one way or another.
Yes,
just to stop it being a complete misfire.
Well, I think this goes back to the point I was making about the past. I think what your lordship is saying is because there's a problem in the past because they didn't know about it, then that's the case. But once you've got the decision, everybody knows about it. I don't see why that would be the appropriate regime, because you would want to fix the amount of DTR credit at the time when it arose in year one, although it has to be carried forward. That would be the normal thing to do. So it rather looks, I think your lordship's instinct really would lead to the conclusion there's different rules before people knew than perhaps after they knew, because of the difficulty that they didn't know. But That's not, I would submit, a breach of effectiveness or anything
Yeah,
like
so
that.
going
Somebody
back to
didn't know.
your metal Gestalt paragraph, I think it was 85, the one that says the procedural
Rules, yes, I've heard the missed
down
that, yeah.
to the national authorities, national laws. I think you would say from that there is no, I'm picking up my Lord's point, that there is no EU requirement to sort of dispense with the need for a claim.
No, exactly, no, I would absolutely say that, yes. And certainly not on the grounds that it happened at a time before. I mean, this goes back to the sort of hidden retrospectivity point,
Yes.
doesn't it, Mr. Justice Marcus Smith? And one can quite understand the instinct that things were difficult in the past because nobody knew about it. But in my submission, a matter of principle, that's not the correct way to look at these things.
Yeah, well, how is it different from any situation where a court decides the law in what is said to be a surprising way?
Certainly domestically, nobody would suggest that you ought to be given a
Plenty of
chance
people have been caught out by domestic decisions of the UK Supreme Court. I mean, it's very unfortunate, but that's just how the law works, unfortunately.
Yes. I think that's the FII claimants might be saying that. So that is issue 10. Issue 11 is a little bit more involved because you have to look at the example that's given on page 195. Of the two years. We're assuming that this, for this purpose, we've simply assumed that this raises the issue that we want. We assume this raises the issue that is required to decide whatever the cases that are going behind it are. The example that's given in paragraph 260. It's a very stylized example, but it's rather like a sort of exam question. What's the result of all of this? So there's 2 years, as you see, and there was dividend income of 100 and management expenses of 100 in year 1. And there was interest income, so the other income in year 2 of 200. So the taxpayer then, again, as seems to be common, showed the dividend income as exempt. If credit had been claimed, full DTR would have been provided.
Now, I appreciate this is not your illustrative example, but can you help me on this? Is the date of May 2020 in subparagraph 4 supposed to be significant?
I don't think so. I think that may have been when the closure notices were actually issued, perhaps in the cases.
But for the purposes of the illustrative example, I'm assuming the date is non-critical. At any rate, provided it's prior to the 31st December 2020, maybe.
Yes. Okay. I don't think the date. Yeah, I don't think the date makes any difference. I think it's just a closure notice was issued. Yes. Right. No, I take that. So the dividend was returned as exempt. If credit claimed, it would have provided the full amount. Because it was exempt, the management expenses were, under the original returns, carried forward to year 2 and set against the interest income. Because presumably also the dividend income in year 2 was returned as exempt as well for the same reason. Set against the interest income, leaving a profit of 100. So there was a net tax liability of 0 for year 1, and in year 2 there was tax of 20% of 100 in this example. And there were inquiries open to both, and both were closed whenever. So under year 1's closure notice, the 100 is now treated as taxable, but it's offset with management expenses of 100 because they should have been set off against the taxable income, not carried forward. So the net result is the same for year 1. closure notice for year 2 shows income of 300 because there's no management expenses now. No DTR is allowed, consequently tax is shown due for year 2 on 300 or 60. Then, on receiving the closure notices, the fund claim DTR at the FNR in years 1 and 2 beyond the 4 or 6 year period. So we have to apply section 8062. That's what all of this is about. Now the problem was the closure notice for year 1 did not acknowledge any adjustment in tax payable in year 1. So what is being said, what's said by the revenue is 8062 can't apply in relation to year 1 because there is no adjustment to tax payable. No claim, so there's no claim in year 1. And that leads to the first conclusion, for depending on how you decide issue 10, is that there's nothing to carry forward to year 2. If you decide it has to be made in year 1, that's the first point. But even if it could be carried forward.
Sorry, just on that, I did ask Mr. Bramner whether issue 11 mattered if the revenue were in issue 10. I'm not sure there's a clear answer.
Well, we would say it doesn't, because that would be an answer. Issue 10, if it was decided in the revenue's favour, would be an answer to issue 11. Because that would be the end of it. There's nothing to carry forward, there's no carry forward.
Yeah.
But even if it could be carried forward, and the claim then had to be made in year 2, that's assuming that what you say is it has to be in year 2. I understand my lord suggesting you don't make a claim at all, but assuming you have to make it in year 2, and therefore you have to apply 8062 again to ask whether you can apply it in year 2. You can't. This is the revenue says you can't apply it in year 2 because the DTR credit was not insufficient because of an increase in tax. Because there was always enough UK tax in year 2 to set the carry forward DTR against, because it can be set against the interest income. If you remember, the carry forward DTR under Salonen and if I Supreme Court 3 can be set against any income in the subsequent years, not just dividend income.
But hasn't followed this entirely. The tax bill for year 2 has in fact gone up because management expenses are now reallocated to year 1.
Yes.
That is an increase, an adjustment to tax payable in year 2. So can you take, for my benefit, please take me through your submission a little more.
If it's right that if carry forward tax DTR could only be set against dividend income, then that would be an answer. I agree. But if we turn up 8062, so I think you can find in the FTT decision in relation to yes, it's on page 181, just convenience. So it's where any amount of credit is rendered insufficient by reason of any adjustment of the amount of tax payable in the United Kingdom or otherwise. So this would be in the United Kingdom. So if it was the case that you could only set the DTR carry forward against dividend income, then the amount of credit would become insufficient by reason of the adjustment of the amount of tax payable, because the tax payable on the dividends would increase. And therefore the credit could be
So-
set against them. But the point is that even before the management expenses were moved, the credits could be set against the interest income.
But do I understand you then?
And the reason they didn't do it is because they just didn't do it.
Do I understand you then to read tax payable in subsection 2 as relating only to dividend income?
No. Well, normally, of course, it would in the application of 806.2, because normally the only tax that we're looking at is the tax on dividend income, because that's all you can set DTR against under the domestic normal system. But I'm applying it to the all of the tax payable. I'm saying that there was tax payable in relation to the interest income from the beginning, even before from the time the return was made.
Yes, but how does that?
And so the DTR credit could have been set against that, so that it didn't become insufficient.
But is this a point about the particular numbers in the example? I think it might be.
Well, it's a point about the fact that there was sufficient, I think it's been constructed so that there is sufficient dividend income. Or there's dividend income which was taxable, but which is now, which was always available for the carry forward. That's why the issue arises, one of the reasons why the issue arises, sorry.
I have to confess, I have not, I will need to, well, come to the shorter journey.
Yes, thank you.
Not sure I have fully understood this.
Okay,
Perhaps it's a convenient point at which to break and
yes,
tackle it with fresh minds
yes.
at 2 o'clock.
Thank you.
If someone could sort out that file, very good.